the meeting to order and welcome you to the October meeting of the Strategic Committee. And trust that you're all keeping well, keeping away from the bugs. I heard a couple coughs around the room, so yes, thank you very much. Keep them all to yourselves, but welcome to the meeting, everyone. And I will move swiftly on. And the first item on my crib sheet, which I will follow, is apologies. And I believe we have a stand-in apology for Andy Kendall, who is recovering from his stroke. Correct, Angela? Thank you. Thank you very much. Item 2, minutes of the last meeting. Is it members who were at that meeting, their wish that I sign those minutes as a true and accurate record?
Yes, Chair.
I will do that. Then I won't walk away at the end, failing to have done it. You could pass that down to Angela. Item 3, apart from all the statutory standing orders and things which members have to register for declarations of interest, are there any new ones which need to be submitted? Andy?
Yeah, thank you, Chairman. The landowners for item 5 are known to me, but I'm here today with an open mind, so I will be taking part in the debate.
Okay, thank you very much. And one other thing I must do, which I always tend to forget, I don't believe we have any fire drills planned for today, but if you, the fire alarm does go off, you can see the exits above the door, follow the signs above the door and listen to the officer's instructions. And with that, I will move swiftly on, and we move on to item 4, which is public question time. Now, I believe we have no members of the public registered to speak on this item. Not in public question. I understand that. I've got the list of who speakers. Right. I will move swiftly on to item 5, which is application to upgrade footpath WN27/4 and part of footpath WN23/11 to bridleways from the A303 Queen Camel to Sparkford Hill, Sparkford. Without any further ado, I will hand over to the planning officer, Sue Coleman, to introduce this item. Sue, over to you.
Next slide, please. An application was made by the South Somerset Bridleways Association in 2017. The applicant claims a public bridleway is missing from the Somerset definitive map from the A303 Queen Camel to Sparkford Hill, Sparkford. Riding or leading a horse.
Can everybody hear? No, move the microphone really close to you and really into the mic and speak up.
A public bridleway, is that better? A public bridleway can be used by the public on foot, with bicycles, or riding or leading a horse. The route claimed is over routes currently recorded as footpaths. Next slide, please. The application route is shown by the blue dashed line from G to F1 to F over the line of recorded footpaths, which are shown as purple lines on the slide. Section G to G1 is along an enclosed track, then G to F1 is through a large open field currently used as grazing for ponies. F1 to F runs through a copse to the A303. The conclusion of the report is that on the balance of probabilities, section G to F1 to F2 is a bridleway and section F1 to F is correctly recorded on the definitive map as a footpath. Next slide. The potential outcomes are 1, to refuse to make an order, in which case the route will remain a footpath. Or if it is determined that public rights exceed those currently recorded, resolve to make an order in the form of one of the following: a bridleway, a restricted byway, or a byway open to all traffic. At the end of the investigation report, a recommendation is made as to whether or not an order should be made to amend the definitive map. Committee members must make their own assessment of the evidence rather than accept the report's recommendation without question. If the committee does reach an alternative conclusion, the grounds for that conclusion must be clearly stated and consistent with the relevant legislation. Firstly, it's important to remember that this application is not about creating new rights, but is a claim that based on historical evidence that these rights already exist, but have not been recorded on the definitive map. The test to be applied in this case is the balance of probabilities, which is determining, based on all the available relevant evidence, whether higher public rights are more likely to exist than not. There is evidence of the physical existence of a route along section F to F1. It can be seen here on the left-hand side of the slide on a plan from the 1873 quarter sessions, and on the right-hand side on the 1887 OS map. However, there is little to indicate it has any higher status than currently recorded on the definitive map. In contrast, the route running from point G towards F1 is specifically recorded in land registry documents as being a public right-of-way and bridle path. It is also consistently recorded in historical documents as a physically significant route. For example, at the top we have the 1903 OS map with the annotation BR to indicate a bridle road. And underneath we have the 1839 Sparkford Tithe map showing the route from G to F1. The 1910 Finance Act documents include a deduction claimed for a right-of-way in relation to the field that section G to F1 lies within. This supports the existence of public rights across the land, although the Finance Act documents do not detail whether the right-of-way is on foot or a bridle way. However, section G to F1 by itself would form a cul-de-sac, so a question remains as to where the bridle path leads if there is little evidence of it turning at F1 to run north to F. The 1898 OS Revised New Series and 1919 OS Popular Edition maps shown on this slide point towards the bridle route continuing west along WN 2315 to Gasson Lane, a public road. The route continuing in a westerly direction is also supported by the 1782 Day and Masters map, with section F1 to F2 forming a continuation of section G to F1. The evidence in favour of G to F1 being a bridleway is then also evidence in favour of similar rights existing over F1 to F2. For land, there has been a claim of the land being held in strict settlement. So I'll just cover some details of land held in strict settlement. If the land over which a public right-of-way is alleged to exist was ever in strict settlement, this might have a material effect on whether dedication at common law can be presumed to have taken place. However, it does not remove any rights which were dedicated prior to settlement, nor does it prevent them from being dedicated after the period of settlement has come to an end. And by settlement, this is a legal document. A settlement is a legal document used to ensure that the land is held within a family for future generations. For instance, a settlement may provide that the land is held by one person for the duration of their life and then passes to their son or daughter on their death. The first person is known as the tenant for life, and the second person is referred to as the remainder man. As the purpose of the settlement is to safeguard the land for future generations, the tenant for life had limits to what they could do with the land, and that includes the ability to dedicate the land as a public highway. The onus of proving that there was no one who could have dedicated the way lies on the person who denies the alleged dedication. It has been submitted that the Mildmay estate was subject to such a settlement. The Mildmay estate included Hazelgrove House and large amounts of land both within and outside of Somerset, including a significant amount within the parish of Queen Camel. However, the total extent of the estate would have varied over time as land was acquired or disposed of. The documentary evidence does indicate that land within the Mildmay estate was subject to strict settlement at certain periods of time, but also indicates that at other times it was held in fee simple, meaning that there would have been someone with the capacity to dedicate at that time. None of the documents explicitly show that the land over which section F1 to F2 of the route runs formed part of the land held in strict settlement. And there has been no evidence to suggest that the land in Sparkford parish, over which section G to F1 of the route runs, ever formed part of the Mildmay estate. Furthermore, there is evidence of the route being in existence at a time when the indications are that the Mildmay estate was held in fee simple. The 1782 Day and Masters map shows a route along a line broadly similar to G to F2 at a time when the evidence indicates that the Mildmay estate was held in fee simple. Therefore, the evidence of strict settlement is not considered sufficient to negate the possibility of dedication. Other issues that have been raised are listed on this slide, summarised on this slide. The first one, the 1795 map of Queen Camel, does not indicate the routes of bridleways. This map doesn't have a key to indicate the status of routes shown on it, and some of the routes shown on the map are modern day public roads. There has been mention about the lime kiln and quarries as evidence that there were only private rights existing for this route. While these features are shown on the 1887 OS map, they do not appear on the earlier 1839 Sparkford tithe map, nor the accompanying apportionment. As a tithe was not normally payable in relation to lime kilns or the stone from quarries, their impact on a plot would have been relevant to the calculation of the tithe. Indeed, lime kilns and quarries are recorded in the Sparkford tithe apportionment at other locations. This demonstrates that while at a later date the application route may have been used for accessing the quarry or lime kiln, it is unlikely to have been its sole purpose. Another issue was that there was no evidence of the bridle route turning north at F1, and the report draws a similar conclusion. Safety concerns have been raised in relation to the bridleway crossing a field used for ponies. And these concerns are understandable, but they cannot be taken into account under the current legislation in coming to a decision about the route. And the application is not for the creation of new rights, but rather the correct recording of rights that are already claimed to exist. In regards to no new evidence, the report, the discovery evidence in this case is that contained within land registry documents. Land registration within South Somerset did not become compulsory till 1989. It is very unlikely that information contained within individual property deeds would have been available for consideration during the definitive map preparation. The public purpose of the route has also been questioned. This route from G to F2 does link two public highways, Sparkford Hill and Gasson Lane. And land held in strict settlement, which I covered in detail on the earlier slide. So in summary, the application route is shown by the blue line from G to F1 to F. The balance of probability test applies in this case because rights on foot are already recorded, both from G to F and F1 to F2. The conclusion of the report is that section G to F1 to F2 is a bridle way and that section F to F1 is correctly recorded as a footpath. That's the end of my presentation.
Guys, didn't take me long to forget to put the microphone on. Thank you very much for that, Sue. I'll say it again. But I'll say I'll move on now where I come on to the speaker part of the application. And I call on Carol Hodder with reference to a letter which she submitted, which she's going to read out. I have to inform you, Carol, that you have 3 minutes. So I realise it may take you longer than 3 minutes to read it out, but if you could just pick out the relevant parts, you will be timed. Thank you.
Thank you, Mr. Chairman. We're rather saddened that you haven't been able to circulate this letter. It's too long for me to speak to you in 3 minutes, but there are very, very relevant information and points that you need to read before I believe, or we believe, that you can make a decision today. So without our information, we feel that you cannot do this. However, I will make these points, these additional points. Now, we believe that this application is not based upon even a reasonable allegation. It's part of a scattergun approach to claiming bridle way rights on the flimsiest of evidence that is neither new, as indicated just now, or relevant. The footpath status has been examined many times before, latterly and in great depth by the Highways Authority because of the new bypass going through, and no objection, and I say again, no objection was made during that process. There's already been multiple opportunities for investigations of all the evidence currently adduced, and it has not been found to be anything other than a footpath. The claim is made without legitimate foundation, but upon the hope that this is wool pulled over the members' eyes by the use of smoke and mirrors, and the belief that the members will fail to recognise this. You can see that common sense indicates and evidence shows that the ancient route was a private common way serving the quarries and the kilns. And although you haven't got the my letter, there was an appendix which clearly showed many routes across there, which clearly could not have been a bridleway. These were private routes taking the stone from the quarries to the two lime kilns, the one down on the A359 and the one further down on Gasson Lane. This clearly was a route to remove stone, not a public right of way, not a public bridleway. Sorry?
20 seconds.
Right, okay. There's no evidence that exists to show public horse use as a thoroughway. And it should, I'm sorry to say, well, I'm not sorry to say, this application should be rejected without further delay. I just wanted to say this is very relevant, this document that we sent to this decision.
Thank you. Thank you very
Thank
much.
you very
for that.
much.
Thank you very much, Mrs. Hodder. It's a pity that the paper, which you say is very relevant, only came in such a short notice that it couldn't be included on the agenda items. And I think, maybe, there's a lesson to be learnt there for everybody. But I can only be governed, as you know, with previous, but no, it's no debate with the rules. But thank you. I've allowed you the time allocated for it. Thank you very much indeed.
Thank you.
Thank you. We now move on to the divisional members. There's no, I believe, parish, town or city councillors that wish to speak. Angela, on this one, notified. The only other notifications I've got is from Councillor Henry Hobhouse and Councillor Kevin Messenger. I don't know if Kevin's present or is he online? Or have you had any written submission from Kevin Messenger, Angela?
Mr. Chairman, Kevin Messenger is unable to come. He's busy with his pub.
That's fine. So Kevin will not be speaking. Right. I will hand over to you, Henry, then, as the divisional member. You too have 3 minutes. And what I will do, I will notify you when there's about 30 seconds to go. Thank you.
Mr. Chairman, I wish to ask the committee to give me more than 3 minutes because I have 6 legal documents here that need to be considered as part of the evidence.
I'm afraid I am sticking rigidly to the rules. I will give a bit of leeway if you need to finish up on a particular section, but you know the rules the same as everybody else does in this room. It is 3 minutes, and once you set a precedent, you've set it forevermore for the meetings which you have. Well, you've done it for that meeting. Why can't you do it for us? So when you are ready to start, Henry, the timer will be fired.
Thank you. Can I have map appendix 17, the 1950 roads record map put on the screen, please? The officers have done a lot of work. Their criteria they've been looking at was set by the Scrutiny Place Committee. It completely fails to miss the settlement and the mortgage law that applies in this case. I'm not going to read it out. I haven't got time. I can give it to you. That is Halesbury Book of Law, which is quoted by the officers on the dedication. They've completely failed to tell you about the settlement land or the mortgages. If you wish to see these, I will give them to you in a minute. I can't quote them. I haven't got time. Settled land is absolutely clear that the owner is not the tenant for life. And in both the 1920 and the 1929 sales document, this land was in settled settled land. It was on the Mildmay estate. It was in settled land on and off from 1793. It is not up to me to prove when and where it was in settled land. It is up to the applicant to prove that there was a dedication when it wasn't in settled land. On top of which, Halesbury, and I've always, that's the wrong map, Mr. Chairman. I want the 1950 road records map, please.
Page 134.
Page 134. Thank you. The other thing that they've completely failed is the mortgages. You cannot dedicate a footpath or any form of right of way while there is a mortgage in place. And there have been mortgages in place on this estate on and off from 1605. I'm not going to prove when they were. All I'm going to say is that on the balance of probabilities, you could not have dedicated a right of way during the period because it was both mortgaged and in settled land. Secondly, the area which is now shown as quarry, G, is a lime kiln. The area that's shown as quarry was on the tithe map shown to belong to the Reverend Bennett. This means it was church land. This means it was also settled land. And yet again, the church land and the church commissioners, as they're now called, they were called the, I can't get it out. Can't get it out. Right, finally, on the conveyances, I brought Sarah Wakefield, Councillor Sarah Wakefield here because she's a solicitor, or was. And I'm going to quote her. We were hoping she would be allowed to speak. On the land registry, evidence there is only one reference to a bridle way, but no map is produced to show where it runs. It is standard conveyancing procedure to use, the widest wording possible to refer to adverse rights which may affect land being conveyed or transferred. No land has been produced to show where the boundary may have run if it existed. I also wish to add to you
30 seconds left, Henry.
that the conveyancing law is so bad that 23% of all conveyances end up in claims against the solicitor who pulled them together. The evidence that a quarry and the land to the west of the application, Northern Arm, was part of the Marlmay enclosure map and can be seen at the Summited Heritage Trust. I cannot understand how we cannot see on that map all the routes that go from the quarry, which belonged on the Marlmay estate, both ways to the main road.
Thank you, Henry. I appreciate you could talk for probably half an hour on the application, but you know, I'm governed by the rules. As much as I want to let you go on, I'll let you go on a minute and a half over time. So, but thank you very much. And I will, what I will do now is ask officers to comment on both applicants' submissions to this committee. Firstly, the letter, which possibly officers I would maybe suggest will not comment on because of the lateness of the paper coming forward. But I will leave that to the officers and hand over them to comment on anything which was said by the two speakers. Thank you very much.
So they mentioned about the application being submitted. We have to deal with each application as we receive it and judge it on its merits and investigate it accordingly. So I can't comment on the applicant's approach. There was a comment that the footpath status has been examined many times. I'm not aware that we've received an application that covers this route previously, and this was the first application received by the Rights of Way. As far as I'm aware, this is the first application the Rights of Way department has received, and the first investigation that's been done by Rights of Way into the status of the route. It was also raised about the quarries and the lime kilns. I covered that in the presentation. I touched on that in the presentation slides. So there is the Sparkford tithe map, which doesn't show the quarries and lime kilns in that position in Sparkford at that time or in that area. So moving on to Councillor Hobhouse comments. So he mentioned about settled land, which I did cover briefly in the slides. The report does go into more detail on settled lands and the documents that were submitted to me, which I researched the originals at the Heritage Centre. There is an appendix included with extracts of those documents and a summary in the report on what's found. The documents from the evidence looked at, there was evidence of the estate being held in strict settlement at certain times, but there was also evidence of it being held in fee simple at other times. In terms of the land, Councillor Hobhouse mentioned that the land was subject to settlement. I'm assuming he's referring to the land over which the application routes run. That is not so clear from the evidence that was submitted. The sales documents he referred to in terms of the land, the sales documents do refer to settlement, land being held in strict settlement, but the portions of land being sold that these documents relate to do not cover the land over which the application route runs. So with one of the documents, there a plan is included, which highlights all the plots that are being sold, that the conditions refer to, that the sale relates to. The plot is not included. The other sale document, it didn't have a plan with it in the records, but it did list all the ordnance survey numbers of the plots that were being sold, and the plots of land over which the route runs was not included in the sale. So it's an indication of the land being held in strict settlement, but doesn't specifically apply to the land over which the route runs.
Thank you for that, Sue. Right, now we're going to throw it out to members of the committee for any questions they may have for officers. Please indicate. Thank you. Martin, Councillor Well.
The beginning and have the just the officer to tell us her recommendations again. I know they're on the papers, but I'm just trying to clear it in my mind actually.
Well, if you like, I will read out the recommendations, and then everyone will hear. It is on page 56. 8. Recommendation. It is recommended that the application which seeks to upgrade part of footpath WN 23/11 to a bridle way between F1 and F1, as shown on Appendix 1, be refused. It is further recommended that small 1, an order be made, the effect of which would be to amend the definitive map and statement to upgrade footpaths WN 27/4 and WN 23/15 from G to F2 as shown on Appendix 1 to bridleways. Small 2, if there are no objections to such an order, or if all objections are withdrawn, it be confirmed subject to the order meeting the legal tests for confirmation. Small 3, if objections are maintained to such an order, it will be submitted to the Secretary of State for Environment, Food and Rural Affairs. Saves the officer reading that out. And is there anything else you require?
Thank you, Chairman. I think I'm one of the ones that have sat through this 3 times now. And it's a very vexed sort of application and things like that. But, you know, looking at all the evidence, I have come to the conclusion, and I will move the officer's recommendation.
Thank you for that, Mike. If there are, we have that moved. If there, yeah, I see Martin's got his hand up. If there are no more questions, but Martin's got his hand up. I would have asked for a seconder, but Martin first.
Oh, yes, I was just going to, in my mind, I mean, I walked this route, I don't know how long ago it was now, and as you say, we've sat through it, so I'm fairly familiar with it. I'm familiar with the land, and I think hopefully with the various arguments, although some of the legal arguments are perhaps not within my scope, but am I right? I'm right in saying, of course, that G to F1 at the moment is that's purely a footpath designation, and now we are asking to turn it to a bridleway. Am I right there?
Just ask for the 100% clarification from the officer.
It is currently recorded on the definitive map as a footpath. The claim is that the higher rights already exist of a bridleway, but weren't recorded at the time that definitive map was created. So the application is a request to add those routes to record those rights.
Thank you, Chairman. So in that case, I would like to second Councillor Caswell's motion to approve.
Thank you for that. I believe I've got a question before I move any further from Councillor Dunk, who is a member of this committee, who is online.
Thank you, Chair. Yes, it's just that the late submission that Councillor Hobhouse tried to outline mentioned, in his opinion, that the mortgages on the land prohibited the ability to dedicate the land to a public right of way or a public route. Can the officer just comment on that briefly? Because to me, that seems that the only impediment, if it's provable, to the application going forward.
She will do that right now.
There was one document submitted that showed evidence of mortgages being obtained, but it was for a very short period of time. And also it's specific parcels of land being mortgaged. It's not the entire, from reading the document, it's not the entire estate. To be the land over which the application route ran being mortgaged, and also being mortgaged throughout the period in order that a dedication couldn't take place. Hope that answers the question.
Okay, well, it's just that Councillor Hobhouse seemed to be fairly adamant that he was able to prove that there'd been mortgages throughout the period, and I presume he means on the land that is dedicated to British football. But the trouble is, this information is probably too late.
Can we not go into a?
Sorry, I'm just finishing off.
You have had your answer from the officer, and you're just quoting what may or may not be, and where the answer you've got is on the question you've got. Unless you've got further questions, Michael, I'd like to thank you.
Thank you.
Thank you.
I'm sorry, we've lost the chair again.
You've lost the chair. My apologies. I said if before I move on, we have a proposer and a seconder for the application. There are no counter proposals coming forward. I will move the recommendation which has been duly proposed and seconded, which I read out a few moments ago in answer to Councillor Wells' question. Looking round, I will ask the members in the room to vote on the application for those in favour of accepting the officer's recommendations on page 56. A show of hands of those in favour, please. Those against? Those abstaining? Thank you very much. The motion is carried. Thank you very much. Now, before we move on, do we want to take a 5-minute comfort break or allow anybody with tickly throats to get a glass of water or anything? So if we say 5 minutes, come back and restart at 10:45? Happy? Quick comfort break? Yes, no, please? Yep. What's he saying over there?
I can't, and I ain't interested, just a troublemaker, and read too much about that.
Okay, could I reconvene, please? If everyone's ready. All right, John? Right, the next item is item 6, a progress report on the phosphates and work undertaken to achieve nutrient neutral development. And I will hand over to Paul to open the item.
Very much. Can everybody hear me? Can everybody hear me now? Okay. Yes. My name's Paul Browning. I'm a Principal Planning Officer here at the Council. I'm here to present on phosphates issues and give an update. Next slide, please. In summary, the purpose of this report is to update on recent events on nutrient neutrality, bearing in mind that this is all about unlocking planning applications. We're also going to outline for information also the anticipated legislative changes by central government in terms of the Levelling Up and Regeneration Bill, which is currently ping-ponging between the Lords and Parliament. Furthermore, we're going to give an update as far as we can in terms of the Council's funding bid for the Nutrient Mitigation Fund. As you're aware from the previous report, it was approximately £10 million bid that we did for the expression of interest. Then, for moving on, we're then going to consider amending the allocation process for the council's Rivertone P credits. That's phosphate credits. That's the council run scheme. It doesn't affect any of the third party schemes that landowners, private developers are actually promoting across our council area. Part 1 and part 2 of the report are for information only. To those ends, there are various recommendations for members to note. Moving on, this committee is then asked to agree part 3 recommendations, which we'll cover in the presentation. Next slide, please. The next one, please, Angela. Thank you. In terms of where we are, you recall in the last briefing, I articulated where we were with the phosphate calculator. That's the calculator that determines the loading of phosphates between current land use and proposed land use of the planning application. I'm pleased to say that Natural England have signed off all the technical data and technical updates associated with this calculator that we reported to in the committee in July. We are now working to actually create this onto the website and work out transition arrangements. What we don't want to do is create an industry of those planning applications have already agreed their calculations under the current calculator, having to then redo them again. Moving on. Once we've done this, we will upload it onto the websites that we've done previously. There will be a video to accompany it so that users will be able to understand what each of the parameters are of the calculator. As we've agreed previously, this calculator has been worked up with Natural England, the Environment Agency, the EA and Wessex Water. And to those ends, it will be the agreed phosphate calculator affecting the Ramsar sites in terms of the Somerset levels and moors. Be aware, though, we do have the River Axe that feeds into East Devon, that goes southwards. That will use the national calculator. Next slide, please. In terms of where we are in terms of stakeholder engagement and lobbying, just be aware that officers of Somerset area teams, Dorset Council, have regular meetings with the Environment Agency, Natural England and Wessex Water. Those of you who were yesterday who were involved in the scrutiny informal briefing will be aware of how that actually plays out in terms of the interaction that we have at a significant level. Moving on, we have a developer forum scheduled for December. The likely date is probably the 7th of December. We haven't yet confirmed that. Those are the regular updates that we gave to the development, those applicants with planning applications presently pending or within the system. We give them the technical updates not only on these planning matters associated with phosphate, but other issues that could affect them. Finally, we continue to lobby central government. As you're aware, and from the committee report, there is a letter attached as one of the appendix to Secretary of State. I would like to advise that in terms of one of our previous letters, we have had now a reply from the Secretary of State. It came in late, it came in yesterday afternoon, along with one other letter, which I'll draw your attention to in due course. We will consider that letter from the Secretary of State in due course and then report at a future meeting date. Next slide, please. As you're aware, When determining planning applications, we work within the law, and the law is often determined by planning appeals. To those ends, we have Jurston Farm, Wellington. That has become what is, inverted commas, I've said here in this slide, is a national test case. It was a planning appeal that was dismissed in August 2022, and you recall I gave further details of that when we last reported to you in July. Just to cut to the chase, the High Court dismissed the challenge by the applicant, CJ Fry and Sons, for the interpretation of the habitats regulations. Basically, what that means is planning applications at reserve matters and condition stages are caught by the legislation. In other words, they have to do an appropriate assessment and habitat assessment, especially when they have not done one at the earliest stages. This reflects the multi-stage process of planning that we have in terms of determining planning applications. The next stage of the appeal is the High Court appeal, but we have no date as set as yet. Next slide, please. Catchment updates. I think this is where I hand over to Emmeline.
Yeah, thank you, Paul. I am going to provide some updates on each of the individual catchment areas. I don't think I haven't attended this committee before, so I'm Emmeline Brooks by way of introduction. I'm a phosphates planning officer. So if we start with the River Brue catchment, currently within the River Brue catchment area, which predominantly affects the Somerset East area, we have 67 planning applications held in abeyance seeking a phosphate solution, and these planning applications equate to circa 1,100 dwellings. Within the River Brue catchment, Somerset Council has signed off 3 private phosphate credit schemes, which we also term third-party credit schemes. You might see that used sort of interchangeably within the Brue catchment. As you can see on the slides, these private credit schemes concern the closure of farms and fallowing land, and these have generated 48 credits, releasing 450 dwellings, a scheme generating 143p credits, which is anticipated to unlock approximately 1,400 dwellings, and a final scheme anticipated to deliver 13p credits, and this has already been provisionally allocated to a planning application in Bruton. Next slide, please. So as is the case at the moment with private credit schemes, the calculations with all private credit schemes, the calculation of the number of credits that those schemes generate and management plans to ensure that they're maintained in perpetuity, which is a minimum of 80 years in line with nutrient neutrality advice, have been agreed with Natural England, and the council has Section 106 agreements in place with those mitigation providers to ensure that those schemes are maintained and monitored as agreed. As is the case with all of these third-party credit schemes, the sales and allocations of the P credits are agreed between the mitigation provider or promoter and the applicant. The local planning authority doesn't have a say in who receives these P credits or how they're priced. And once those private P credits have been allocated to planning applications, the developer or applicant comes to the council with a certificate confirming that they have been allocated those credits, and that's what they intend to use as their phosphate mitigation to ensure that their proposed development is phosphate neutral. Also in the River Brue catchment, there have been a limited number of applications where applicants have progressed their own mitigation solutions. So what this means is that they're not using P credits and instead they're progressing their own mitigation projects. And in the Brue to date, this has comprised woodland planting and also the upgrade of poorly performing packaged treatment plants or septic tanks to more phosphate efficient models where it's not possible to connect to main drainage. Next slide, please. So if we move over to the River Parrett, which primarily affects the area south, there are approximately 320 planning applications held in abeyance seeking a phosphate solution in the River Parrett catchment, which equates to around 4,500 dwellings. This, however, this 4,500 dwelling figure does include about 2,500 dwellings that are at the post-committee Section 106 stage, so we're working through a Section 106 agreement to secure mitigation following committee decision. To date in the River Parrett catchment, 240 dwellings have either been approved or are resolved to approve subject to a Section 106, with their mitigation solution being the package treatment plant option that I just mentioned. There are around 160 dwellings that are using retrofitting of existing properties with water efficiency measures as their phosphate mitigation solution. We've also got planning applications that are utilising woodland planting, fallowing land, which is a temporary mitigation solution, moving to a permanent solution later down the line. And also there is a scheme with more of a rolling, provided by a provider, a rolling scheme of septic tank replacements with more efficient package treatment plants, which generates those third-party P credits. Next slide, please. So also in the River Parrett catchment, as members will be aware from the last meeting, the Entrade P credit scheme is in operation. In terms of an update, Entrade has run its first market round. This has allocated phosphate credits to 80 dwellings and 2 care homes within the River Parrett catchment. And it's expected that a second market round will be run around now during autumn 2023. In addition, Somerset Council is also drafting Section 106 agreements within the Parrett catchment to enable the release of 2 third-party, so private land use change projects, which is, again, short-term land fallowing, moving towards a wetland or woodland solution. And together, these schemes that are being progressed are expected to generate around 270 phosphate credits. So I think linked to the above, it's worth sort of mentioning at this point as well, we are seeing, officers are seeing a number of sort of these third-party private credit schemes emerging across all of the 3 catchment areas that feed into the Somerset Levels and moors. And we are working with mitigation providers to get these schemes in operation across the catchment areas. And also to that end, we're working on updates to the phosphate web page to be able to signpost applicants to these solutions as they become available. Next slide, please. Thank you. So as Paul mentioned earlier, and as you'll be aware, the River Acts Special Area of Conservation catchment is also affected by nutrient neutrality advice. A shorter update for the River Acts, but after the committee report was published, we did receive notification of a recent appeal decision, which effectively supports the council's current approach towards nutrient neutrality requirements. It involved 2 schemes in the Tapworth area, which totals around 48 homes, and this was refused on phosphates grounds because adverse effects on the protected River Acts catchment area could not be ruled out. In this case, the applicant had suggested off-site mitigation, nature-based solutions such as creating wetlands to reduce the nutrient output of the proposed development, but this was not included in any of the unilateral undertakings submitted as part of the appeal, and therefore the inspector didn't have the certainty that the development wouldn't affect the river catchment as a result of increased phosphorus loads. And there was also use of applying condition to update outdated ecological surveys, which was also dismissed by the inspector. Next slide, please. So the River Taunton catchment, which primarily affects Area West, there are approximately 100 planning applications within this river catchment held in abeyance seeking a phosphate solution, which equates to circa 3,000 dwellings. In the River Taunton catchment area, the council has a council-led rather than a third-party P credit schemes, and this is, as far as we're aware, only one of a handful of councils across the country that has such a scheme. As a bit of an update on the River Taunton P credit scheme, We've currently run 2 rounds of that scheme, offering credits, Rivertone P credits as they're called, that's the council credits, to affected applications within the Rivertone catchment. To date, 53 planning applications have been offered credits as part of round 1. And we've received, out of those 53, we received 29 applications from applicants to acquire those credits. And this is equated to 8.5p credits that have been allocated, releasing around 41 new dwellings. We commenced round 2 of the scheme earlier this year, and they started with offers to 22 planning applications, and so far we've received 4 applications where their phosphate calculations and shadow habitats regulations assessments have been approved by us for them to progress to Section 106 agreement to secure the credits. Next slide, please. So similarly to the other catchment areas, as we've just heard, we've also had planning applications progressing within the Rivertone catchment area, where applicants have been progressing their own phosphate mitigation solutions. And this has primarily comprised, similar to the other catchments, the package treatment plant upgrades, woodland planting, orchard planting, and wetland solutions. And as I mentioned earlier, we are liaising with third-party credit providers for schemes in the Rivertone catchment area as well. So finally, just on the kind of specific catchment area updates, it's also worth mentioning that we've prepared a guidance note both for development management officers across Somerset and for applicants to assist in the preparation of materials to submit as part of their planning application to be able to demonstrate nutrient neutrality. It covers basically potential mitigation options and the information that we need to see to be able to progress their planning application. And that applicant guidance note is now available on the website. Next slide, please. And I think I am handing back to Paul.
Thank you very much, Emily. Next slide, please. In terms of updates, central government, first of all, levelling up and regeneration bill. As I alluded to earlier, there was some, as we say, turbulence over the late August, early September of this year in terms of nutrient neutrality. It did hit the public headlines in terms of national news, etc. To those ends, I'll just cut to the chase in terms of government proposed amendments to the habitats regs assessments. And those were voted down by the House of Lords on the 13th of September. Therefore, they will not form part of the Levelling Up and Regeneration Bill. The provisions contained within the Levelling Up and Regeneration prior to those late amendments that were inserted at the Lords stage will take place if enacted. Our understanding at this moment is that additional information, legislation will come forward as part of the King's speech, but we have no further information at this time. And those of you who've been listening to the debates occurring in the Lords and Parliament at the moment, House of Commons, will see that ping-ponging various amendments between each of the houses. Next slide, please. So we've got a level of uncertainty going on at this moment in time. Where we believe we are currently at is that there is a new duty on water companies to upgrade their wastewater treatment works in designated areas by 2030. In essence, what it means is that a wastewater treatment, a sewage treatment plant that serves a population of over 2,000 is likely to be caught, and therefore will have to enact improvements to what we call achievable technical limits, TAL. And for phosphates, that's 0.25 milligrams per litre. However, it still needs to be enacted as part of the parliamentary process. As I said, these means that it will not apply to all wastewater treatment works, especially in rural areas. And as you're aware, for example, on the River Parrett, the Brew and the Taunton, we have a number of wastewater treatment works that serve populations significantly lower than that. We wait to see what the detailed legislation is if enacted. So watch this space. As we said, and the final point is that Royal Assent will they have to enact the Levelling Up and Regeneration Bill by the time we have the King's speech on the 7th of November. So watch this space. Next slide, please. In terms of where we are terms of the government's nutrient mitigation bid, as you're aware, we submitted an expression of interest for approximately £10 million. And the details are there. It was seeking a capital of 9.63 million and revenue of 0.9 million. And that was in perpetuity to unlock development between now and 2030, effectively creating temporary credits. So we could actually bridge our situation between now and 2030, when hopefully the Levelling Up from Generation Bill and all those requirements come into effect. However, we've sent 2 letters, as we've alluded to in our committee report. We've had one back from the Secretary of State. It really doesn't take us that far forward in terms of where we are on our bid. It doesn't say that we've been successful. It doesn't say that we haven't. It's still being considered. To those ends, what we will do is place that letter on our website. It was to Councillor Ross. As I said previously, all our letters, in terms of our lobbying letters, are on our website, and we do keep our website up to date. We do have also one other letter that came in very recently, and that was affecting the next part of the presentation. That was from Care UK, and that was seeking to widen the criteria of an amendment to include C2 uses. What we would do, given the lateness of it, given the uncertainty of where we are, we will have to come back in due course to consider amendments to the P credits. What you're asked to do today is actually just amend in light of where we currently are. So we will review C2 uses and other uses as part of a future amendment. But I will now pass over, I believe, to Emmeline in terms of the next slide.
Yeah, thank you, Paul. Sorry, next slide, please, Angela. Thank you. Yes, so I'm going to provide a bit of an update now on the recommendations that you'll have seen within the committee report, which concern the allocation of Rivertone P credits. I've just given an overview of where we are in terms of allocating the first 2 rounds of the council-led scheme, and this section focuses on how P credits as part of that scheme have been allocated to date and what officers are proposing in terms of changes to that allocation process. So the Rivertone P credit scheme started operating and allocating P credits to affected planning applications in December 2022. And since then, P credits have been allocated to affected planning applications on a criteria basis. Rivertone P credits have been offered to applications that have been held in abeyance as a result of the nutrient neutrality advice coming in August 2020, in accordance with the priority criteria, which was agreed by the former Somerset Western Taunton Phosphates Planning Subcommittee. And the criteria approach was developed based on 7 identified scheme objectives. They're on the slide within the committee report, so I won't read those out now, but the focus was on the scheme meeting those objectives. Next slide, please. So in terms of looking at those objectives and working out how they could inform an allocation process, as part of round 1, it was agreed by the former Somerset Western Taunton Phosphates Planning Subcommittee that first priority for Rivertone P credits would be afforded to planning applications for minor housing development, which was planning applications within the C3 use classes or traveller accommodation, and with minor being as per the definition of a minor planning application. So applications comprising less than 10 dwellings. I'll come on to implementable development and that requirement in a moment, but because of the requirement of implementable development, priority was not afforded at round 1 to outline planning applications, but all other planning applications that fell into that minor housing development category were offered phosphate credits. Round 1, as I mentioned earlier, we sent out letters to offer phosphate credits to around 50 applications. Once we had progressed as much as possible with the applications that had come through and said they wanted P credits as part of round 1, we had sufficient P credits available to be able to run a second round of the scheme. To that end, the Phosphates Planning Subcommittee, as part of former Somerset West and Taunton Council, agreed what the prioritisation would look like for round 2 based on those scheme objectives. And it was agreed that priority for round 2 would be given to minor housing development that weren't included as part of round 1. That would have been because they weren't ready in all other planning terms. So there might have been outstanding planning issues such as highways that needed to be resolved before progressing to receive phosphate credits. And another priority towards both major and minor planning applications where the proposals exceeded affordable housing policy requirements. And in all cases, since the start of the scheme, it's been agreed that Rivertone P credits should be allocated to applications for implementable development. And what that means is implementable development is defined as development which can commence on site within 3 months of planning permission being granted. So once the decision notice is received by the applicant, they'll have agreed a Section 106 agreement which requires them to commence on site within 3 months of that planning permission being issued, unless otherwise agreed with the council. So if that, as you know, things happen, that doesn't become possible, they can come back to us. But in the first instance, 3 months is the agreed time period for commencement. And that was linked to the objective of ensuring timely delivery and wanting the Rivertone P credit scheme to unlock development and result in development on the ground as quickly as possible. The focus of the scheme at the start was on planning applications that were on the list held in abeyance. So since August 2020, for them, when the nutrient neutrality advice came in and they didn't have mitigation solutions. And to that end, for round 2, there was a date criteria. So P credits were only offered to planning applications that were on the list of applications held in abeyance awaiting a phosphate solution as at the 30th of March 2023. And essentially what had happened previously is that once all other planning matters had been resolved on those applications and the applicant was only awaiting phosphate mitigation to be able for planning permission to be issued, it went onto that list, and then that was the list used to allocate the P credits. Next slide, please. So since the scheme began sort of allocating P credits, it has been almost 12 months. And officers have identified a need to reflect and review on the progress of allocating the available P credits that we have generated from the current mitigation project that those P credits are linked to. And this includes the way in which Rivertone P credits are allocated to phosphate affected applications. And this is based on the uptake of P credits to date and the number of P credits currently available, which stands around 30 credits that are remaining to be allocated to affected applications. And if we come on to next slide, please, we can come on to the recommendations. So it's proposed to retain some elements of the prioritisation criteria as it stands, but also propose some changes. So officers are proposing that Rivertone P credits are still prioritised for housing development. So that's C3 use classes and traveller accommodation. We've also linked with kind of supporting SMEs and also in acknowledgement of the fact that for minor applications, it can often be more difficult to be able to access mitigation. We are proposing that the remaining 30 P credits are split essentially into 2 pots. So we have 10 Rivertone P credits that are ring fenced for planning applications for minor development. So that would be applications for less than 10 dwellings, with the remaining sort of 20 open to both applications for minor development, but also larger schemes as well that seek to access the scheme. We're also proposing that the requirement for implementable development, so the 3-month commencement on site, is retained. And we're also proposing that rather than having the kind of date criteria, this the scheme would be available to applications that are at any point seeking phosphate mitigation solutions and want to access Rivertone P credits to do this. And the focus at the moment is on the criteria, and then we will have to, officers will have to put in place kind of processes for being able to allocate the P credits in accordance with any changes that are agreed. And the reason that this option has been recommended by officers is it's considered to maximise the scheme's contribution to the objectives, whilst ensuring that the Rivertone P credit scheme facilitates housing in a timely manner. And I think the report recommendations are on the next couple of slides, including the for information elements of the report. So that's just for a reminder, but they're as written in the committee report. And happy to take any questions.
John?
Thank you, Mr. Chairman. Yeah, thank you for that. It's a lot to take in. Yeah, so in terms of P credits then, just to help me a little bit, I'm a little bit confused where I think further back in the presentation, Emily, you said that there was 8.5 P credits with 41 representing 41 houses. I've asked this question many times before, but I think the last time I asked, it was each P credit that's on the Rivertone part was about 9 to 10 units, whereas obviously 41 divided by 8.5 is about 5. Is that because these are exceptionally big properties, or is it? I mean, I think that we based that, or you guys based it on the 9 to 10 on sort of a 3-bedroom semi-detached house as an average unit. So that's the first question. The Tone P credits, are they solely for building in what was the old Somerset Western Taunton district area? And in terms of the last part that you said, you mentioned that there are 30 credits available. Does that mean there are only 30 credits left? And if that is the case, that at 9 to 10 is a maximum units, clearly that's only 300 units. If it is at 41 to 8.5, it's only 150-ish units. So there's not a lot left on in the Tone area. That being the case, are we now looking at, as a council, buying more of these? Because that clearly has been quite a big success, hasn't it? Thank you, Mr. Chairman.
Oh,
Yep, thank you, Chair. Responding to the questions in the order they're asked, I recall that the amount of P credits, bangs per buck, you get effectively depends on significantly which wastewater treatment works you're actually feeding into. To those ends, that's what the calculator does, because it's one of the integral parts of the phosphate calculator. But also there are a whole series of other things in terms of rainfall, local topography, soil types, etc., etc. I'm not going to go into the details. So typically in a Taunton urban locality, one credit will unlock probably around about 10 homes. If you're in a more rural locality, say Wellington at the moment, prior to improvements, half that. And if you're in a really rural locality, half it again. This is why the purpose, as agreed by the former Somerset Western Taunton Council, was to actually prioritise these planning applications, these small applicants that for no reason other than they do not have potential to actually provide their mitigation on site. What is their solution? They have no solution. So that was the purpose of the credit scheme. Moving on then, that links it to the Rivertone. It was to the former Somerset West Taunton area, the Rivertone area. The map that I've shown previously to you with the 3 coloured areas, the pink for the Rivertone, the Parrot and the Brew. So it's purely for the Rivertone catchment area. And then lastly, third parties. Thinking on about the number of credits available, our appropriate assessment on the website, we signed off a scheme of mitigation. Nature-based solutions was one in terms of where we are currently providing from a third party where we've got a legal agreement. They are progressing other land use proposals at this moment in time. We've also, as part of the schemes, we're looking at providing a wetland in Copford St Luke. We're looking at the technicalities of that, and that was all part of our appropriate assessment. Also water efficiency measures as well, in terms of Somerset, Western Taunton, the former council had its own housing stock. It did not do a housing transfer, unlike South Somerset to Avery now, etc., etc. To those ends, we were looking at water efficiency measures as well to top it up. So it wasn't just one solution, it was a number of sources for these P credits. Also, there are third-party credit schemes coming in. Our initiation 18 months ago, 2 years ago, we've learnt a lot in terms of doing this ourselves. So we're passing that knowledge on to developers and landowners who are now bringing forward their third-party schemes. And that's part of the update that we've given in terms of you've now seen the wide variety of third-party credits coming forward. I think I've answered all the questions there, Tony.
Thank you for that, Paul. Okay, John.
Thank you very much. Thank you for that. Just a follow-up on that then. In terms of cost, has the cost increased from what it was? I think we averaged out at £5,000 a unit on 10 units per, I've forgotten the word. Yeah, so has the cost increased? That's the main thing. And with the new government law, does that then change if it comes in November? Will that then change this whole game, which it sounds like it will, and wash up and make all these ones we can't pass now passable?
Right. In terms of the cost, the average cost has not changed. It is approximately, as I said, 55k per one credit. That credit releases a significant number of homes, and that will vary spatially. In terms of moving on, when the LURB is enacted, what that means is your one credit will go farther, because you can also take account of wastewater treatment works, which are currently operating for phosphates approximately 1 milligram per litre. Fresho, for example, Taunton, they were operating at agreed technical achievable limits at 0.25. So your one credit will go further. Thus, the average cost per home in terms of creating that reduces.
Thanks for that, Paul. Okay, John. Yeah. Simon, I see you had your hand up online, but I'll just go to Mike Caswell first in the room, and then I'll come back to you.
Thank you, Chair.
Yes, thank you, Chair. First of all, I hear through my phone, and if you're talking that way, I don't hear a thing. So please, just speak into the microphone. The other thing is that I represent many local small settlements, as our colleague over there does, scattered throughout the Quantock Hills and what you might call the Steert Peninsula area, all of which are on septic tanks. Most of them discharge into their own property through soakaways and things like that. I get, the larger settlements, the Cummages, the Leatherstowies, the Canningtons, Wendons, and all the places like that, actually have sewage treatment works and are connected that way. But what the small settlements and sometimes an individual property has is a septic tank. And I get a lot of complaints or worries, I should say worries, not complaints, that they are going to be hit by some fantastic charge because of the phosphate scheme. And, through no fault of their own, they look after those septic tanks, I can assure you. And there's very, very, very little pollution. And they tend not to use the phosphate kind of things because they're in the washing powders and things like that, because they damage the septic tank. So what is going to happen to them?
You answer that, Paul?
Our expression of interest in the Nutrient Mitigation Fund bid articulated the fact that there are private companies out there, and one of them is articulated within our bid, whereby they were upgrading septic tanks to PTTs, etc. I would like to point out that certain parts of the former area north, as it's now called, around Bridgewater, the area that you often cover, talking about the context, are outside the River Taunton catchment area. They're not caught by the phosphate issue because they're not directly or hydrologically linked to the Ramsar sites on the Somerset levels and moors.
Well, Mike, just to come back, there are companies going around telling, especially the elderly that live in the houses with septic tanks, that they have to upgrade and it will cost them thousands of pounds. And it is a worrying time. And I think we ought to mention that in some respect.
We acknowledge that. We're also getting inundated with residents and others asking about P credits. To those ends, we're going to be updating our webpage shortly, listing those applicants that have got P credits that have actually got planning permissions tied to them. So we're in terms of a one-stop shop in terms of information to actually try and address some of the issues and the concerns that residents and others are having. So it is on our agenda to do in the next few weeks.
Okay. Simon,
Chair,
as I
thank
said,
you.
I'd go to you next. I know it's offline and there may be someone else who wants to speak in the room.
I don't doubt
Good,
that.
go ahead.
Okay, thank you, Chair. My apologies for not being there in person. My first meeting overran and I couldn't get back in time. So my apologies for that. I have been here for the whole meeting. I've got a couple of points, if I may. First is to pick up on something John Hunt said about the government's position, which we may or may not know at the beginning of next month. I would welcome any further detail on that. And secondly, on this question of P credits in the River Taunton area, we at Planning West yesterday, we were told that there are no further credits available. They had run out, they'd all been allocated. Has anything on today's presentation changed that? Because I notice on the reports on the screen now that 10 River Taunton P credits are ring fenced and can only be allocated to minor applications for housing development, i.e. proposals for less than 10 dwellings. As I say, yesterday it was indicated at the Planning West Committee meeting that there were no P credits available for applicants. So I'd just like to clear that up because that seems to be in contradiction for what we're being told at today's meeting. And further clarification on where we think the government situation is with credits. Thank you. Thank you, Chair.
Thank you, Simon. Anybody else wishing to speak in the room? Henry?
To apologise. Yesterday, Natural England confirmed that phosphate reduction improvements in each wastewater treatment plant will count towards phosphate credits. Does the phosphate calculator include this input, or are you going to put it in later?
Sorry.
We will be, it takes account of the LURB 2030. In other words, any planned improvements. So what we know at the moment, there are planned improvements for Wellington, which will be included in the revised calculator. And we anticipate, as I say, anticipate that the Levelling Up and Regeneration Bill will be enacted as currently drafted. The aim will be, there'll be a part of the calculator where you'll be able to actually compare and contrast pre and post 2030. So in other words, yes.
Can I come back, Mr. Chairman, very quickly? There are, as far as I know, 6 different water, whatever you want to call them, cleanage, sewage, cleanage, whatever you want to call them, in improvement status as we speak. One of which is Castle Carey, which is removing 6 tonnes of phosphate from the River Carey, which, as far as I can see, will meet every one of your P credit requirements in the near future.
Who's answering that? anything, or that just for information? Okay, okay, Henry, noted by the officers. Yeah. Anybody else wish to speak on this particular?
Yes, please.
Carry on.
Thank you, Chair. It's just a question really about, I can see why you're letting minor housing developments through at less than 10. The only trouble is they don't normally have to include any affordable housing. But I welcome later on you say that applications that exceed affordable housing policy are being prioritised. And I think that's a great idea, because otherwise we desperately need affordable housing and it's going to lag behind. But what I wondered was, bearing that in mind, is what is the tendency for developers? Are they wanting to build now smaller houses because per house they will have to buy less credits, if you like, and that should in theory encourage more of the 1 and 2 bedroom accommodation that we desperately need. It's been proven that we need. Or has it going to have to the opposite result? Is it going to, developers are going to say, well, we still want to build 3 and 4 bedroom detached executive homes, and therefore these phosphate credits will affect the viability of our application, and therefore we cannot supply the affordable housing that we would normally be asked to. So is anyone able to see what these the effects are going to be on applications going through?
Crystal ball comes to mind here.
We might have some evidence already, Chair. I don't know.
Paul?
The calculator assumes a standard occupancy. The current standard occupancy rate is 2.4 per property. However, Natural England will sign off on, for example, 1 bedroom flats. Clearly, if it's a 1 bedroom flat, then there's not likely to be 2.4 people in that there. Therefore, they will agree those as exceptional circumstances.
Right. I'm gonna, sorry. Simon, did you get all the answers you wanted on your question before I move on?
No, Chair. I was wondering what the situation with the P credits was and where we felt we were with the government scheme.
Right, Paul's going to answer it for you.
Thank you.
I'm going to come back.
Okay, thank you,
Chair.
Alison.
In relation to the Levelling Up and Regeneration Bill, as Paul's alluded to earlier, they're still playing ping pong between the Lords and the Commons. It went back to the Commons yesterday, and as I understand it, it's now going back to the Lords again. So, as Paul has said, we are anticipating that the upgrades to the wastewater treatment works will be a requirement in the Levelling Up and Regeneration Bill, and we're still hoping it will receive royal assent before the King's speech on the 7th of November. If it doesn't, then it will go back into the melting pot. So there is still a level of uncertainty, and I think that is why we're seeing in a number of changes in terms of applications coming forward and so on. In answer to your second question about the eligibility criteria, based on the current eligibility criteria for P credits, the scheme that was before the Area West Committee yesterday didn't meet the criteria. And that's one of the reasons why we're coming back to expand the criteria, or ask committee to expand the criteria today.
Okay, thank you for that clarification.
Voice down, Henry, please.
Thank you for the clarification.
Can we have one
Alison,
meeting,
Chair.
please? We just have one meeting, please.
Thank you,
Okay,
Chair.
Simon?
Yes, thank you, Chair.
Okay. Martin, is your question?
Sorry, I had to leave an urgent phone call, but if this has been asked before, stop me. But representing a, how we call it, a watershed ward over at Chard, and why get applications in both areas, you very early in your presentation, the officer said that the ACTS scheme, it comes under the government scheme, I believe, and that's what you said, whereas the rest comes under the Parrot. What is exactly the difference in the government scheme, and how is it working, or does it work yet for those applications which we have to deal with in the Axe River? Is that all right?
The difference is use of the calculator. The calculator is only for the Somerset authorities. It is for those that feed into the Ramsar sites. The River Axe doesn't feed in to the Ramsar sites, therefore they use the national calculator. In terms of those who have used both, I will tell you one thing, our calculators are far more user friendly.
Okay. Right, I'm looking around the room. Hang on a minute, John. I don't see any more hands up, and I will say, because you've had a couple goes, but I want to point out one thing here, and just for clarity of the recommendations which we're asked to agree. But I want some legal advice here, because members that have left the room during this debate, whether we can make a decision or do a vote on this, because were we quorum or were we not? So could I have some legal clarification on it, please? And while that's being sorted out, could I just say that I think the membership of committees, I think, needs to be looked at, because I think, we're getting a repetition of members not turning up, or even notifying democratic services that they are not turning up for committee meetings, which are important. And when the meetings are quasi-judicial, you need to have everyone there present. Thank you. Could you answer me, please?
Sorry, thank you, Chairman. Yes, you're quite right. We've had two of the members left the room during that debate. I think Councillor Caswell and Councillor Walsh, who unfortunately won't be able to. Sorry. Wales, sorry. Apologies, sir. Won't be able to take part in the voting, but I understand, and I'm looking to Angela, that we have remained quorate throughout that debate, that there are still 5 members that are able to vote.
Right, that's fine. That is fine, but it still didn't hurt to make the second point about members turning up for meetings. Thank you.
I apologise, Chairman.
No problem at all.
It was most important matter,
Yeah.
which I don't want to go into.
Caswell,
I will apologise also, but when you've got to go, you've got to
you've got to go. Quick question. I'll make this the last one.
It is quick, Mr. Chair, just based on what we've heard, particularly from Simon. I'm just a bit concerned about what we as councillors now, so a resident comes to us and says, we're looking at building a house. What do we do about all these P credits? What, from the officer's viewpoint, it would be the advice they would recommend to us to give to residents now? Because clearly with only 30 P credits available I can only speak for this area. Where do we go with that? I mean, what advice do we give? That's my question.
I would hope that you would advise them all to seek, if that material pre-planning advice, if it's applicable to.
Is that the officers' advice?
But
There are a number of sources. They can email us on the phosphate email address, which was on our presentation. They can look on our website, and they can speak to a lower ward member or speak to us. Our contact details are on the website.
all right, John. Right, I'm going to move to the recommendation on this one now, and I'm going to do it in 2 stages, if you're happy with that, because the first section is for us to note A, B, and C, and I think are all members happy to note those A, B, and C of the recommendations? Noted. Thank you. Now, how do you want to do the next section that the Strategic Planning Committee agrees? Do you want to take each one separately and vote on them, D, E, and F, or do you want to take them en bloc? Happy en bloc? Right, thank you. I thought I'd give members the opportunity. Do I have do we need a recommendation? Yeah, but I said, do we need that? We have the recommendation. I was going to say, do we need a proposal for the recommendation? Sorry, Alison.
I'll move that, Chair.
Right, thank you. A seconder? John, thank you. All those in favour of D, E and F? Yep. Thank you. Those against? Abstentions? You did indeed. Thank you. Right, we move on to the next item, which is item 7, which is the quarterly report on the planning service performance. And I believe Alison's going to take this one. And this one should be reasonably interesting because there are gradually going to be, or imminently, as Alison might say, some things coming forward with regarding planning, which is going to affect members, all members. Over to you, ladies, whichever one's going first, Alison or Helen.
Apologies. This is the second report to this committee on the planning services performance, and it covers Q1, i.e. the period from April to June 2023. We're always a bit in a time lag because of when we have to report the statistics to the government. So the statistics for Q2 will be submitted at the beginning of November. So I haven't got those formally yet. So next slide, please. So this information today sets out the volume of work that's been received by each of the area teams and the waste and minerals team, and as I said, reports information which is published nationally on a quarterly basis. So at the beginning of September, they reported the information in relation to Q1. Thank you. Okay, so next slide, please. So what I'm going to cover today is the number of planning applications which have been received by the council by area, and we're looking at it on a time series basis. So it includes the latest information of Q1, but it also shows you the trend in terms of applications that were received. So it's a continuation, if you like, of the information you received at the July meeting. And then I will specifically cover the performance on major, minor and other applications determined within the national targets for Q1, which is the government national measure. And then there's some information around pre-application inquiries, the appeal decisions and enforcement cases on hand. In the appendix, you will see that there is also information on 5-year housing land supply and housing delivery test, but that information is only collected annually and so hasn't changed from July. So I haven't put it on the slides, but for completeness, we've re-included it in the appendix to the report. Next slide, please. Okay, so this slide shows you, and apologies, it's come out rather small on the screen, but this just shows you the number of applications that have been received by quarter in the table on the left, and the graph on the right just gives you an indication of the trend by area team. You'll see there's been a slight reduction, particularly in the north area, of the number of applications in Q1 received. We think this is possibly due to delays in validation in Area North, which has been caused by a loss of staff in that team. We have now recruited, I'm pleased to say, to those posts, so it should improve, but it probably will only show an improvement in terms of Q3. So we are aware that there is a backlog there, which we are seeking to address. If you look at the appendix, you will also see in the appendix charts 2 to 5, which show not just the applications received by quarter, but the number of that have been determined and the number that are on hand at the end of each quarter. And you'll see that all of the areas are not determining as many applications as there are on hand, and that's defined as having a backlog.
Now, some of that backlog is caused by the applications which held in abeyance because of phosphates, which we've just been talking about. And that's certainly part of the story. But we do have a recruitment and retention problem and a turnover of agency staff, particularly in the south area. We have a number of vacancies across the service. And indeed, we had a further resignation last week. As set out in the report, this is a national problem. It's not a problem particular to Somerset, although the circumstances we find ourselves in here probably have not made it any easier for us to recruit. But a recent RTPI survey showed that 82% of local authority planners said they were having difficulties hiring planners in the last 12 months. And for most of that, the issue was competitive salaries. So that is something that we are addressing. We are working with HR colleagues to develop a workforce strategy to try and address the issue. But I think, I suppose my answer is there's no easy answer to this because of the national picture and the national shortage of planners. We are increasingly having competition from the private sector as well as other local authorities in terms of obtaining particularly experienced staff. We've been very successful in recruiting apprentices and graduates, but unfortunately getting them to stay when there's a multitude of offers out there is more difficult. Moving on, the next few slides, well, this one shows you how the areas have been performing, and the minerals and waste team have been performing compared to the target set nationally by government. So we are required to determine 65% of major applications within 13 weeks, 75% of minor applications within 8 weeks, and 85% of other applications within 8 weeks. The diagram to the right just shows the performance for Q1. The lines, horizontal lines, showing you the target, so that you can see that on the whole the targets have been met. We have had issues in Area West in Q1, and I think that was largely because of the changeover to the new authority and issues with the referral system to members, which we've now addressed. And I'm pleased to say that the figures that we've submitted for Area West for Q2 show performance now at 75% majors, 89% minors, and nearly 93% for others, so well above the national targets. Next slide, please. So the next few slides just show the trends for each of the area teams from 2020 to 2021 up till Q1. So you can see there is a bit of variation in terms of performance over that period of time, and that obviously reflects changes in the market, applications coming in, and staffing issues to some extent. Next slide, please. So that's Area North we've just seen. This is Area East. Particularly, you can see here that the volatility in terms of major applications, and that's because obviously in any quarter we're not necessarily determining that many major applications, so one major application not meeting the target has a big impact on the percentage. Next slide. So that's Area South. Again, I think there's been a dip in terms of performance for majors for Area South, probably caused by the fact that they are now able to address the phosphate situation and starting to take more of those applications through the committee. Next slide, please. And I've mentioned the issues in Area West, which I'm happy to say have been addressed and will show an improvement for the next quarter. Next slide, please. So this slide is important because one of the other things the government does is to designate authorities who are not meeting performance over a 2-year period, and indeed they do threaten to intervene in those areas. So the table on the right shows the performance for minerals and waste, which, as you can see, is very good, and the performances across the rest of Somerset and the different areas. The data for Somerset as a whole only represents 1/4, and that's because we've only been in existence as an authority for 1/4. So we haven't got the rolling figures for Somerset. So what we have done is to manually, internally, do the figures for the 4 different former districts and now areas within Somerset, and you'll see we are well above the targets that the government would be imposing for designation. So that's just to reassure you that we're not likely to get a letter or be in the frame anytime soon. The next slide shows the level of pre-application inquiries, and this is included really to show you that obviously not all of the work is just on determining planning applications captured by the national statistics, but we also have a lot of other work in the system, including the pre-application work. We are going to be looking at the way we charge for pre-application inquiries as part of putting forward proposals for fees and charges next year. Next slide, please. The next few slides show the appeal decisions. Again, it shows the trend in terms of appeals dismissed and by the inspectorate. Again, this is very volatile because of the small numbers of decisions that go to appeal. And again, if you only need 1 or 2 to be approved or dismissed for us not for it to affect the figures. So probably not reflected to take just 1/4, but we've just included the previous years so that you can see what the trend is. The appeal decisions themselves are now being reported on a quarterly basis to each of the area committees. So members are getting to understand the issues that are raised through those appeals. So that was area north, area east. Next slide. Area south and area west. And then the minerals and waste team. Again, very small numbers, so very hard to draw a pattern or any information from that. But again, appeal decisions is one of the areas that the government looks at when they're seeking to designate authorities as not having met the criteria. But I'm happy to report that none of us are in that position. Next slide. And this is just to show you the volume of enforcement cases which are in the system. Again, we've taken the data to the end of Q1. Just a reminder to members, of course, that enforcement is a discretionary activity. It's not something that we're required to do as an authority. And we do have an adopted enforcement policy, and cases are assessed in relation and addressed in relation to that enforcement policy. And I think that's the end of it. As I said, I haven't put up the slides, but I was pointed out that there is one factual inaccuracy in the report itself, which I'd like to amend, which is that Area South does not currently have a 5-year housing land supply. I know further work is going on in relation to looking at the 5-year housing land supply in Area South in relation to a current appeal that's about to go to inquiry. Thank you, Chair.
Thank you, Alison. Well, members, as you can see, quite a complex report in front of you. I think you need to, in some instances, read it time and time again to get your heads around it. I mean, we are only asked to note the content of this report, but I don't think I would be speaking out of line when I say that the planning chairs do meet of all the planning committees, planning chairs and vice chairs regularly, and there are changes which do need to be made to the planning because we have to be aware of the risk implications to this authority with appeals and non-determinations and everything else. And one thing which did become apparent was that early in the new year, I believe the Constitution Committee will be reviewing certain policies and what have you. I mean, Alison can touch on it if she wants, but it was stated at the last planning chairs and vice chairs that it needs to be the people with the knowledge of the plan and making the decisions on the planning criteria and how the planning should work, and not just committee members with no planning experience. That was the bottom line of it, and I won't go into any more details at this moment in time. But also that training is a factor for every member across the board, because it's quite apparent that some members really have not got their head around the planning and planning policies and what they are doing to make decisions. But I will leave it there. And I don't think I've spoken out of line. Right. I'm going to go in the room first, Mike. I see you've got your hand up. I'll come to you in a minute. Steve.
Thank you. The table on table 19 on page 197, which is the trend in enforcement cases closed, that would be better illustrated by the actual trend in outstanding cases and possibly the ages, because although it may be not a statutory requirement to do enforcement, it is something that brings the whole planning system into disrepute when it's seen to be blatantly disregarded. So it would be better illustrated by the amount of the trend in the amount of outstanding work there is, rather than the numbers closed, because the numbers closed probably just reflects the amount of work that's been put in rather than the overall picture.
Alison?
Well, I pointed to chart 23, which actually does show you the number of cases which we've got on hand. So that does show you the thing. Going forward, we will be able to do the trend. Prior to the new authority, everybody was doing things in a slightly different way. So in order to provide consistent advice to you and information to you, we've only been able to do it from the beginning of the new authority coming into being. So we probably haven't got that historical data that we can go back to, because it's not recorded in that way. It's not measured by central government. So we haven't been keeping it in a consistent way.
Thanks, Alison.
Right. On the shortfalls re-housing supplies, which are different for each of the areas, obviously it means, does it not, that the planning system is actually four planning systems, in fact, because, or does it mean that we can knock together all the lack of or shortfalls or surplus, and do we have to, the government, is it looking at the whole of Somerset, or is it looking at those old districts? Because it seems to be totally unfair that some areas have got a surplus, but should the government come down and say, well, you know, these are not good enough on the other areas, the whole of Somerset falls into the catchment of government inquiry? I'm sorry, that sounds a bit complicated, but have you got the point of it?
Before Alison comes back, I'll do it through the chair and she will correct me if I'm wrong. It is one council. We are Somerset Council. But no, doesn't that apply now?
So
what about moving forward?
So if I can explain, at the moment we have adopted plans in the different areas. So we are currently, in terms of housing land supply, the calculations is based on the housing requirement figures which are set out in those adopted plans. So we've actually got 5, because the former Somerset West and Taunton has got 2 adopted plans, and those are the figures that you see there. In terms of housing delivery, which is a different matter, which is the second area that's identified there, at the moment we are being it's calculated in the different areas, but that will come together more quickly on a Somerset-wide basis than the plans. As Tony's just said, we're working towards a new Somerset-wide local plan, which will set out our housing requirement, and it's that at that point we will be measured in terms of 5-year housing land supply against that new plan. So for the next few years, the answer is we're separate.
That's what I thought, but is it viewed separate by the government still?
Yes.
So it'll be like it's still South Somerset or Mendip or whatever when it comes to a shortfall.
In terms of
Yes.
it's related
Okay.
to the adopted plans.
Yeah.
Yes.
Thank you. Yeah, thank you, Chairman. Sorry, Chair, can I?
Yeah, come back,
Yeah,
by
thank
all
you.
means.
Not on that, on what you were saying about going forward, and I think it was the Constitution committee yesterday. I think they were talking about setting up a workshop or work stream or some sort of thing, which was involving chairmans and vice chairmans of planning committees. And does that include your good self? And
sorry, it will include all the planning chairs and vice chairs, correct, Alison? Of all the 4 areas and the strategic committees. I mean, it's a mammoth task of everything right across the board with officers and what have you, with planning, with shortages and everything else, and trying to bring a uniform service right across the whole of the Somerset Authority. But it's we've got to get. There is a lot of things which we can do ourselves in-house by listening to the members of what is not quite right and what could work better. There's a lot of instances, you know, like who can speak, who can't speak and what have you, and it's got to be done for what is the best. But I mean, it's when it's laid down in the Constitution and in policy at this moment in time, you can't, you know, you cannot deviate from it, but we've got to have a consensus across the board. That's basically it, Martin.
as I understood it, there isn't any going to be member involvement with that work stream, but as I understood it from yesterday's committee meeting, members are or should be encouraged to submit any evidence that they may have. And I presume it'll be a meeting which members can go along to, because I think it's important. It strikes me that this, as you said, Tony, it's an important matter being set up. And I'm rather perturbed that it is being somewhat restricted in influence by members.
Come in, she'll probably answer that for you.
Those wonderful forms that are in front of you, the ones that we've asked you to fill in every meeting, they are vital to this piece of work. So we do make a plea, please, that you give us your thoughts on those so that I can collate them. That's a piece of work I'm doing at the moment. All right, that is how you guys are feeding into the constitutional review process at the moment.
I've just been reminded in my left ear, Councillor Dunn, online.
Thank you, Chair. I thought you hadn't forgotten me. It's just I mean, I might be a bit naive here, but we are having a problem recruiting staff, and it's a nationwide problem. So it's not just down to us. Have we any leeway where we can raise the salaries in order to attract more staff, or are we tied into some sort of complicated a system where we can't do stuff, like we can't react to situations that are clearly developing in the country? I just wanted to know what we can do about it, because it obviously is a problem, and whether we can pay more, I don't know.
I think everyone would like to be paid more, but I won't answer. I won't answer it, and I won't ask our finance officer, who's not finance officer, our executive member who's sitting in this meeting. But I would think the answer at this time with the financial situation would be very doubtful.
You are, because of our financial situation, not individually as Somerset.
I don't know. All I would suggest is you go to all the financial meetings. But I'm going to ask Liz to come in and get.
Thank you.
to the debate.
Thank you, Chair. I don't think I'll be a couple of minutes, just to say that there is a grading system for Somerset Council, as there was for all the predecessor councils. With regard to pay rise, annual pay award, that is part of a national pay bargaining. So we're still waiting for agreement on pay award for this current financial year. Still hopeful it will come this side of Christmas. But I do not feel in any way competent to comment on grading of pay within this council. But I do understand that it's an issue with recruitment and retention. Thank you.
Thank you.
Thank you for that, Liz. Better put than the way I did, but there we are, Michael. The answer is doubtful, is still no. Ross, I can't even.
Thank you, Tony. Sorry, I'm struggling coping with two meetings at the same time. I think I was just going to echo very much what Liz has said. As with many technical roles within the council, there is quite a sophisticated grading and job description process, and it doesn't necessarily within local government lend itself to readily being changed. There are market forces and other things which be brought into play, and I think Alison indicated earlier that there is a piece of work going on about recruitment and retention of this professional group of people, and that no doubt will come back to your committee in due course.
Thank you for that.
Thank you, Ross.
Thank you, Michael. Good. Right. All you're asked to do, and I ask you, is to nod your heads. We are asked to note the content of this report. Noted. Noted. Thank you very much. That, I believe, brings a better check meeting to an end. It does indeed. I cannot tell you the date of the next meeting because I don't have it to hand. But if someone could give it to me or state it, that would be fine. It's the 23rd of November. I don't believe we've got anything that we need to stay behind for offline for the committee to discuss, but I do believe we may be having a couple of waste applications coming forward, but maybe not.
I believe the way the constitution is framed at the moment, any applications go to the area committee, and if they are then determined contrary to officer recommendation, they come before this committee.
There you have your answer. So we will have to wait and see what we have coming forward to the committee. But I think, as we've said at the other meetings, there needs to be certain changes made within the planning of this authority at this moment in time. Thank you. Right, I'd like to thank everyone for their time this morning. And John, you're in plenty of time. Yes, thank you. There we are. And thank you all for your attendance.